I'm always trying to get better results for the veterans I'm working with. That means I'm following trends out of the VA. I'm trying new things from time to time, and I'm generally trying to follow up on the things that tend to work. And since it's January 2023, I thought I might as well talk about what my current general strategy is with VA appeals. If I were to summarize this strategy in a single sentence, it would be to say that I like to patiently play the long game. I like to set things up early, build a solid foundation, and then start appealing. What I do is take a very hard look at what evidence is missing from the claims file. In other words, what does the veteran still have to prove in order to win? It can be anything. It can be a lay statement, a medical record, a service record, a medical opinion, whatever it is. If something's missing, I'm going to go get it. I'm going to work with the veteran to track down all the evidence we still need, get it together, and submit it with a supplemental claim. And if we get a decision on that supplemental claim that makes me think we still might be missing something before the VA is going to grant it, we'll go get that evidence and we'll file another supplemental claim. And I keep doing that. I live in the supplemental claim space until all the evidence is there. Then once the evidence is there, start appealing, going for higher level reviews and board appeals and to the court if we need to. Consider what's going to happen if you don't have all the evidence and you start appealing anyway. You're going to go up on a higher level review, or you're going to get in front of a judge at the board, and they're going to issue a decision that either denies your claim or remands it back down to the regional office for them to continue to develop it. Those appeals eat time. All the appeals eat time. So if you can spot missing evidence ahead of time, you can save yourself that entire appeal period. I think that ultimately leads to a better decision faster. Okay, so what are the exceptions? So first of all, let's say I just start working with a veteran and they're coming up on that 1-year deadline to appeal a decision, and we don't have enough time to gather the evidence we need. I might file a higher level review defensively. The VA is probably going to deny everything again with the higher level review, but once that decision comes out, it resets the 1-year clock. Now, that's a minor exception. The bigger exception happens when the problem in the case is going to turn on whether the VA is going to go with the veteran's medical opinion from his doctor that says the disability is service-connected, or if the VA is going to go with the CMP examiner who said it's not service-connected. In those situations, I take those problems straight to the board. I need to say, only if I think the medical opinion we have is strong, it's solid, it says everything that it needs to say for the VA or the board judge to grant the claim in the veteran's favor. Then I take that straight to the board. Here's the problem. In the last 2 years, I'm hard-pressed to think of a time when a VA rater at the regional office or a higher level reviewer made a decision that went against the VA's CMP examiner. That specific problem is going to take a video of its own to talk about. The point is, they don't do it. Now, I've convinced many higher level reviewers that the CMP exam is terrible, but I can't convince them to grant the claim based off the exam the veteran provided from a fully qualified expert. What the higher level reviewer does is remand it back for another CMP exam. And that doesn't help. It results in multiple bad CMP exams clogging up the C file. The board is much less likely to do that. If you can present the board with a good medical opinion, and you can poke a bunch of holes in the VA's medical opinion, you can create a situation where there's only 2 potentially, and you can get one essentially thrown out. So there's only one left. And again, if that one's valid and it's the only one on the table, you're much more likely to get a win at that point. But if you've been doing that churn below where you get a remand for another exam and it's another bad exam, by the time you get up with the board, you've got 7 or 8 exams. 2 or 3 are from your doctors, and you've got a whole slew of CMP examiners. It's a mess for the board to sort out. I would rather avoid that if I can. Still, I do think that even in that situation, you're going to get better results at the board than you'll ever get anywhere else. I should add that there's very good veterans attorneys that don't necessarily agree with that approach. The thinking generally goes that board appeals take so long. You got to brace yourself for 3 years at least at this point. It's awful. And they take so long that if the facts are there, they think they can go through that churn between the higher level reviewer and the regional office and get a good decision faster. Depending on the specific facts, there may be cases where I would agree with that approach. But as a general rule, I don't think it's a good way to go. But I do want to say reasonable minds do differ on that point. And fair enough, this whole area is complicated and it's a lot of going with your gut. All right, so thinking about what I just recorded, it feels a little disjointed. So I'll try to summarize real quick. My strategy is, number one, look at the file and ask if there's missing evidence. If yes, go get that evidence and file a supplemental claim with it. If no, then start appealing, higher level review, and then to the board, and then higher if you need to. And the only exception is I take medically complicated cases straight to the board. If we have a good medical opinion that supports what I'm trying to do for the veteran. So I hope you found this helpful. If you'd like me to help you with your disability claim, you can reach out to me through the links below. I'm Al Walsh, a veteran who likes to help other veterans. Thanks for watching.